The Rehabilitation and Social Services Committee will now come to order. We do have a robust docket. I just have a few announcements. We have an identical bill before us, and we know that we're going to pass that out. For those who may be in the Zoom waiting room, for House bills that are similar to Senate bills, I'm going to ask our General Counsel, David May, to explain the difference between the House bill and the Senate bill, and then we will move to conform the House bill to the Senate bill. So we'll be putting a substitute on that House bill. We will not be taking comments, and we will not be asking the House members to present. We're going to go right through the similar bills because this committee has already had public comment on that topic. We've had a Senate bill that's similar to the House bills. Other than that, we will proceed as we normally would with our calendar. Okay, first item is House Bill 1879, Delegate Bulova, and this is what we often call the cocktail to go bill. It is word for word identical to Senator Bell's bill. I would like a motion to report.
Madam Chair, don't we need to call the roll?
Oh, excuse me. Thank you, Senator Boysko. Thank you so much. Will the clerk please call the roll?
Thought I had saw Senator Reeves. Madam Clerk, you have a quorum.
Thank you. That's okay. It's early this morning and we had to hassle with the snow. So let me go back to House Bill 1879, which I had just explained, and I believe there was a motion to report. Okay, motion to report by Senator McPike, seconded by Senator Mason. Please open the roll.
Ayes 11, noes 0.
Okay, bill reports. Okay, now we're moving to similar bills. House Bill 1805, and I believe that is similar to Senator Barker's bill, but I will ask General Counsel to explain the difference.
Madam Chair, this bill is similar to Senator Barker's Senate Bill 1366. The bill basically requires DARs in providing aging services to prioritize providing services to persons with the greatest economic and social needs, and it defines those two terms. To conform, it would need 6 line amendments that have been posted online. You can access those. Differences are mostly technical. The only one of note really is the 4th line amendment. I'm happy to read those if you want, or if y'all just want to look at them online, we can do it that way.
Thank you. Motion has been made to move the amendments. All those in favor signify by saying aye. Aye. Anybody opposing? Hearing none. The amendments pass unanimously. Motion has been made to report by Senator Mason, seconded by Senator Boysko. That bill will report with amendments. Clerk, open the roll.
Ayes 9, noes 0, 1 abstention.
Bill reports has amended. Now we're moving to House Bill 2167. It's Delegate Scott's bill. And as I recall, we had 2 Senate bills that dealt with different sections of what his bill deals with. This all has to do with parole, notice and certification monthly reports. I will ask Mr. May to go ahead and do a summary.
Madam Chair, yes, House Bill 2167 is similar to Senate Bill 1104, Obenshain, and Senate Bill 1397, patroned by Senator Norment. This particular bill, this version of the bill, requires DOC to wait 30 days to release an inmate on discretionary parole or conditional release after notice has been given to DOC by the parole board that parole is granted, with the exception that if conditional release is granted for someone who's terminally ill, you can do it in less than 30 days. It requires the parole board to notify the Commonwealth Attorney of any decision to release an inmate. Again, the 30 days, and it also modifies this monthly parole report, requiring that be issued by the 15th of the month and include certain information that was also part of the Senate bills. We would need a substitute to conform, and basically the big differences are regarding the notice to the Commonwealth Attorney. The House bill says that the notice has to be given electronically, and it has to be given 30 days before the release, whereas the Senate bill requires that it be sent via certified mail and electronically and 21 days before release. The House bill requires that the monthly parole report be issued by the 15th of the month. The Senate bill says it's to be issued on the last day of the month. There's a couple other minute differences, but with the idea being that we were going to conform and let them work this out in conference.
I think that sounds,
Madam Chair, I'd make that motion.
thank you. Well, why don't we first move a substitute, because we're blending two bills, so and this does have to be referred to finance, does it not, Mr. May? It does. Okay, so I'd like a motion to adopt the substitute and refer to finance. Senator Cosgrove made that motion, and Senator Mason seconded that. I believe that's a roll. Okay. All those in favor of the substitute signify by saying aye. Aye. Okay, now I'd like a motion to report the substitute and refer to finance. Okay, that motion was moved by Senator Mason and seconded by Senator McPike. Clerk, please open the roll.
Ayes 11, noes 0.
Very good. Thank you. Okay, now we're moving to House Bill 2197, Delegate Runyon, and it has to do with our DMAS and the work group. And do you want to explain that, David?
Madam Chair, this is similar to Senate Bill 1472, patroned by Senator Suderline. Came out of this committee and the Senate unanimously. The bill requires DMAS to study and develop recommendations regarding the use of virtual supports and access to such virtual supports by persons with intellectual and developmental disabilities. It requires DMAS to report its findings to the Governor of the General Assembly by November 1st, 2021. To conform, we would need 4 line amendments that have been posted online. One of them is technical, and the other is just to add a report to certain committee chairs.
Second.
Okay, very good. All those in favor of adopting the amendments which would conform this to the Senate bill signify by saying aye.
Aye.
Aye. Okay, I would like a motion to report the bill as amended.
Second.
Okay, motion has been made by Senator Mason, seconded by Senator Boysko. Will the clerk please open the roll?
Ayes 11, noes 0.
Thank you. Now we're on House Bill 2266. Patron is Delegate Ayala, and this had to do with the, you probably recall, our outdoor, is a version of a special event kind of issue where we were allowing local governments some authority to set up a bourbon-like environment with control of the ABC. But I will ask, I think there was only a slight change between Delegate Ayala's and the Senate bill. I thought it was a nomenclature, but go ahead and explain, Mr. May.
Madam Chair, that's correct. The bill allows ABC to increase the duration, frequency, and size of local special events if a locality passes an ordinance allowing such increases, and it provides for higher license fees if the provisions are invoked. And basically, the only real difference between this bill and the version that came through the Senate, Senate Bill 1471, patroned by Senator Donovan, is the name of the license. This committee decided to retain the current name of the license, but the substantive provisions are the same. So we would need a substitute to conform.
Motion has been made that a substitute be adopted by Senator McPike, seconded by Senator Mason. All those in favor of the substitute signify by saying aye. Aye. Now I would like a motion to report the bill with a substitute. Motion has been made by Senator Mason, seconded by Senator Reeves. Will the clerk please open the roll?
Ayes 11, noes 0.
11 noes, 0. Very good. Thank you. Okay, next we're moving to House Bill 2312. I have this bill, the number memorized, the delegate hearing, and of course the Senate bill was 1406. It was Senator Evans and Lucas. This has to do with marijuana, the marijuana legalization, retail sales, and any penalties. So I believe we would want to move a substitute. Hopefully we'll adopt the substitute, which would be conforming delegate hearings bill to Senator Evans and Senator Lucas's bill, and then we'll report it and re-refer it to finance. So I need a motion for a substitute. Senator Cosgrove moves a substitute. Senator McPike seconds. All those in favor of this substitute signify by saying aye. Aye. I'd like a motion to report the substitute and re-refer it to finance. Okay, motion made to report and re-refer to finance by Senator Boysko and Senator Mason. Will the clerk please open the roll?
Ayes 7, noes 4.
Finance Committee will be happy to receive this. They asked us to move it quickly, so we'll send them a quick text. Very good, colleagues. We're now moving to non-companion bills. So these would be House bills without a Senate companion. Our first cluster are ABC bills. So let's start with House Bill 1845. The patron is Delegate Van Valkenburg. I don't know if he is in the queue. Is he in the queue? Okay. Please let Delegate Van Valkenburg into our Zoom so he can explain his bill. Delegate Van Valkenburg, welcome to the committee. Would you like to unmute yourself?
Yeah, hey, thank you, Madam Chair, members of the committee. How's it going?
It's going fine. Thank you for joining us.
All right, so House Bill 1845. So this bill is a proposed bill that would delay the effective date of the 2020 alcoholic beverage control license and fee reform from July 1, 2021 to January 1, 2022. During the period of the delay and subject to some requirements, the bill would allow on-premise wine or beer licensees to sell wine or beer for off-premises consumption, and allow such licensees as well as off-premise wine or beer licensees to deliver wine and beer. And this is a response to COVID. This is to help restaurants and our small businesses. ABC and others kind of worked out the 6 months and agreed that 6 months was a good delay to allow them to continue to kind of be able to survive and make money and not have to pay these fees on these licenses in the short term, and would not have an adverse impact on the kind of big reform we passed last year to kind of streamline these licenses. And so, we have something like over 5,000 businesses that this would impact. It is a small business bill, and I, hope that you guys would look favorably upon it.
Thank you. Is there still an emergency clause on this?
Oh, yes, thank you. I always forget to bring that up. There is an emergency clause on this so that we can ensure that these businesses are able to keep operating and hopefully not just survive, but thrive during these times.
Thank you, Delegate. Is there a representative from ABC in the Zoom room? I can't tell.
Yes, ma'am. Madam Chair, John Daniel, Virginia
Welcome, John.
ABC. Good morning, members of the committee. This is there you just want me to
Yes,
talk
do you have a
about the-
comment on 1845? Is that acceptable to ABC?
Oh, more than acceptable. We worked with the stakeholders during the course of the interim to come up with this delay to try to, as Delegate von Valkenburg has indicated, to try to give them a little bit more breathing room for another 6 months as we continue to navigate COVID. So we're fine with the bill and appreciate the delegates' work. Thank you.
seems like a very reasonable bill, especially during this time where restaurants have really suffered such a reduction in traffic volume. Any other speakers?
If you'd like to speak to the bill, please raise your hand.
Otherwise, we're ready for a motion.
Move to report.
Motion has been made to report by Senator Morrissey and seconded by Senator Boysko. Will the clerk open the roll, please?
Ayes 13, noes 0.
Delegates, your bill reports.
Thank you, Madam Chair, and thank you, members of the committee.
You're welcome. Okay, let's go to House Bill 1973. Delegate Rush. Is Delegate Rush in the?
Yes, Madam Chair.
Very good. Would you please present your bill? House Bill
Yes.
1973. Go ahead.
Oh, thank you, Madam Chair, members of the committee. This bill is pretty simple. It allows nonprofits who are having virtual fundraisers, and you guys have probably seen this throughout your districts. You'll have a virtual fundraiser dinner, and then the meal will be shipped to your house. This would also allow the meal to be shipped wine with it. This was brought to me by our local Chamber of Commerce, who was doing their annual dinner virtually, and more or less in response to the COVID license or the COVID crisis. Thank you, Madam Chair.
Thank you, Delegate Rush. Is Mr. Daniels still in the queue?
Yes, ma'am, Madam Chair.
Thank you, Mr. Daniels. Would you like to comment? This is an ABC bill.
No concerns from ABC on this bill. Thank you.
Thank you. Are there any speakers in the queue?
Chair, if you'd like to speak to the bill, please raise your hand.
No speakers? Okay, colleagues, the bill is before us. Do you have any questions of the delegate, or are you ready to make a motion?
Move. Second.
Motion has been made by Senator Boysko and seconded by Senator Mason to report the bill. Will the clerk please open the roll?
Ayes 13, noes 0.
Delegate Rush, your bill reports.
Thank you, Madam Chair, members of the committee.
Thank you. Okay, we're coming up on our last ABC bill, House Bill 2131. Patron is Delegate Lopez. Delegate Lopez, are you in the queue?
Yes, Madam Chair, members of the committee.
Welcome. Would you like to make a presentation on your bill?
Thank you, Madam Chair. We often hear about bad actor commercial establishments in cities and localities where there are repeated ABC violations as well as fights, drug deals, and shootings. Where necessary, ABC has always been a responsive and helpful partner in working with our localities to impose fines and suspend liquor licenses for these establishments. In order to help localities address these kinds of bad actor establishments, and after having worked with numerous advocates from the restaurant and business community, HB 2131 makes notice for county or locality staff easier, and it gives the locality more authority to require a property owner to correct issues relating to criminal blight by adding possession of controlled substances in the criminal blight definition and strengthening the discharge of a firearm section. Madam Chair, I hope it's the will of the committee to report the bill.
Senator.
Thank you, Delegate Lopez. Mr. Daniels, are you still in the queue? I'd like ABC's comment on this.
Yes, ma'am. I'm still here. John Daniel, Virginia ABC. No comments from us. We worked with Arlington County and their local officials to develop the bill that's now before you, and appreciate Delegate Lopez's help with that. So thank you very much.
Thank you for your comments. Are there any speakers in the queue?
If you'd like to speak to the bill, please raise your hand.
2197.
I see no hands, Madam Chair.
Okay, colleagues, the bill is before us. Motion has been made by Senator Boysko to report, seconded by Senator Mason. Will the clerk please open the roll?
Ayes 13, no 0.
Delegate Lopez, your bill reports.
Thank you, Madam Chair, members of the committee. Have a good morning.
Thank you. Okay. Now we're going to move to bills in the social services area. And I know Delegate Helmer is probably not in the queues. He is not. Okay, so we're going to have to move around a little bit. Is Delegate Levine in the queue? He's not. Delegate Gudaitis. Okay, Delegate Gudaitis, we are going to work on House Bill 1962. Let me rephrase that. We're going to consider House Bill 1962. Would you like to present it?
Good morning, Madam Chair and members
Good morning.
of the committee. Thank you very much. Yes, HB 1962 will ensure that more of Virginia's children who come to the attention of the child welfare system can be raised by relatives when parents cannot keep or regain custody. My favorite thing about this bill is that it actually codifies fictive kin, people who are not necessarily related by law or by blood, but who want to give the child a loving home. And I, having known a number of families who fall into that category, I'm very glad to have that in this bill. It also makes the age of the child, it changes it from 14 to 12 when they can be involved in making their own decisions and making their own plan. So Virginia right now is the second worst state in the country for children aging out of foster care without a permanent connection to any family. Focusing on kin first will help Virginia do better by these kids. So having relative custody is also useful to provide extra time to a parent struggling with addiction or other challenges, as the foster care timeline clock is not ticking. So this is supported by the Virginia Poverty Law Center and Voices for Virginia's Children. I believe that Valerie LaRue is hopefully from Virginia Poverty Law Center in the room to answer questions that are beyond me, Madam Chair.
Thank you, Delegate Gudaitis. This sounds like it's expanding the safety net for our most vulnerable children and giving them another avenue for permanency. So thank you for bringing the bill forward. Is there anybody from social services? Is M. Parente in the room, or? Okay. Okay, so I think social services was fine with this. Ms. LaRue, did you want to speak briefly?
Thank you, Madam Chair. Only to say that thank you, Delegate Gudaitis, for bringing this bill, and I'm happy to answer any other questions. Oh, there's M. Parente if you wish to hear from her, but we do support this bill and thank Delegate Gudaitis for bringing it. Thank you.
Thank you. Ms. Parente, do you have any comment from social services on House Bill 1962?
Madam Chair, it took me a minute to get out of the waiting room into the speaking area.
I understand.
M. Parente, Division of Family Services for the Department of Social Services. We have no problems with this bill.
Okay, very good. Okay, colleagues, the bill is before us. Okay, Senator Boysko made a motion to report, and it was seconded by Senator Mason. Will the clerk please open the roll? Okay.
Ayes 13, no 0.
Delegate Gudaitis, your bill reports. It's on a 13-0 vote.
On behalf of these children, thank you.
Thank you. Let's go to Delegate Willett's bill. It's House Bill 2092. Is Delegate Willett with us? Okay.
Good morning. Thank you, Madam Chair.
Good morning.
And I'll speak to the bill. HB 2092 is a bill that will extend the background check and central registry requirements for contracted staff that are in direct care positions for behavioral health services. There are staff members right now that are really frontline in providing these services. They're actually coming into patients' homes to provide the services. And through some work that behavioral health did, they were essentially cleaning up looking at their code sections. They realized that under the current law, that not all these contracted employees are required to have background checks. So this bill would clean that up and put the same background check requirement in for those workers as is done for other workers right now. And I hope that this body will report this bill. Thank you very much.
Thank you, Delegate Willett.
Madam Chair. Ani.
Senator Mason.
Thank you, ma'am. Delegate Willett, this great concept, great idea. Have you had any conversations about backlog and background checks? We've wrestled with this over the last couple of years, and depending on when and where you're talking about, it seems like we do it mostly with child care workers, and there's been a pretty significant backlog. Have you spoken to anybody about where we are this year on that and how that may impact your bill?
Madam Chair, speaking to the senator's question.
Yes.
Yes, Senator, I am definitely, I share that concern, because I in my professional life have run into some with my own employees, run into issues with his background checks. To answer your question directly, I am not aware of a current backlog in that. I know that's certainly been a concern in the past. And again, this is putting folks into the same process that's already done. It's just essentially closing a loophole for people who are not getting background checks right now. But your question is well taken.
Thank you, ma'am. Thank you, sir.
Thank you. Is there a department representative in the queue? Anybody from the Department of Behavioral Health with us?
Good morning, Madam Chair. My name is Emily Bowles from the Department of Behavioral Health.
Good morning. Thank you, Ms. Bowles. Would you like to comment on this bill, and especially maybe you could respond to Senator Mason's comment? I don't know if you heard it. His
Yes,
question.
ma'am.
Go ahead.
This is an agency bill, and DBHDS supports this bill. And to get to the question related to backlog of background checks, we asked our staff when we were putting together this bill. And the background check turnaround that we heard is for the providers who are directly contracting with staff. It takes around 48 hours to receive the results of the background check if there are not any hits on crimes. If there are hits on crimes, that's when there is a longer period of time. The wait time can be 1 to 4 weeks. But if there are not any hits on crimes for the background check, it takes around 48 hours to receive the results. And then DBHDS disseminates the results within 5 to 7 days of receipt. And then for the state police checks, which we would be using for the temp agencies, those take around 15 to 20 business days to process.
Is there a fiscal impact on this? I don't have a note to that effect. I'll ask David May. Is there a fiscal impact on this? No, mine doesn't indicate that either. Any other speakers on this bill?
Madam Chair. Madam Chair.
Senator Morrissey.
For the young lady from DBHDR.
Ms. Bowles.
Here's the question. Is the barrier crimes for those individuals who provide contractual services more or less extensive than those other individuals who provide direct care?
I believe they're the exact same.
Right, further question.
Senator Morrissey.
How extensive or how far down the pipeline do you go for providing contractual services? Would it include the person that delivers the water cooler?
Specifically, so we would be looking at the definition of direct care services within the code. And that is any person that includes responsibility for treatment, case management, health, safety, development, or well-being of individuals receiving services, or immediately supervising a person in that position. So someone delivering a water cooler, no sir, would not fit within that definition.
Thank you, Madam Chair.
Okay, so that clarified a question I had. Okay, colleagues.
Move to report.
Okay, motion has been made by Senator Mason to report and seconded by, okay, Senator Sorvell. Will the clerk please open the roll?
Ayes 14, no 0.
Delegate Willett, your bill reports.
Thank you, Madam Chair. Thank you, members of the committee.
Thank you. Let's move to House Bill 2191. Is Delegate Lethwich? Okay.
I'm here, Madam Chair.
Thank you. Thank you for joining us. Could you explain 2191?
So the best way to explain this bill perhaps would be to give the committee a fact pattern that I confronted as a lawyer. So there was a situation where a wife obtained a protective order against her husband, and that there was no custody proceedings pending. The husband took the child and hid it from the mother. The mother informed the Department of Social Services. They went to check on, they were able to locate the child with the father and check on the child, found that it was not in danger. And the mother obviously asked, well, where is the child? And the department said, we can't tell you. So what this bill does is it allows the Department of Social Services to inform a parent or custodian of a location of a child if they know where it is, with an exception. And that exception is if that disclosure would endanger the custodian or parent who actually has the child in their physical custody. And that's it.
Thank you, Delegate Lethwich. Is there a representative from Social Services? Is M. Parente still in the queue? Or?
Madam Chair, this is M. Parente. I'm here.
Welcome. Would you like to comment on House Bill 2191?
We have some concerns about how broad the bill is. It creates a potential area of work that is not currently work that the departments are responsible, the local departments are responsible for. Clearly, when there are custody issues between parents, there can be a lot of activity between the parents trying to get information. And this is not specifically related to abuse and neglect, which is the scope of work that the local departments are primarily responsible for in regards to CPS situations.
Madam Chair.
It does seem broad. Is a question from Senator Morrissey. Senator Morrissey.
It's a question for the patron, Delegate Lethwich. Delegate Lethwich, give me a classic scenario or situation in which this bill would apply. It obviously doesn't apply when one guardian, one parent takes the child to Wintergreen for the weekend and the other person is inquiring about it. What are you trying to address specifically with this bill? And give me an example.
So the example that I gave would probably be the most classic situation. I'm a little surprised about the department's comments. I didn't hear any of this when the bill was moving through the House. And from my perspective, if you have one parent who's taken the child and essentially hidden the child from the other parent, the department would only become involved if that parent made an allegation of abuse and neglect. That's when that's the only time they would really be motivated to investigate or be required to under the current law, as I understand it. So again, in my fact pattern, the mother had a significant other or spouse who had shown a propensity for aggression. Thus, the protective order that was entered against him as it relates to her. And when the father disappeared with the child, she was concerned for the child's health and safety and filed a request for a abuse and neglect check. The department checked on that, found that the child was not in danger, but still the mother, I think, has a right to know where the child is if the department is aware of it. There's nothing that requires the department to investigate this just because a parent wants to know something. It would only fall under the situation where they're already involved pursuant to an allegation of abuse and neglect. I hope that's responsive. It's a little bit more verbose than I'd hoped it would be.
I have a question for David May. I'm concerned with line 24, where the language seems, I don't know, very judgmental. It says, unless the local department finds that such disclosure would compromise the safety of the child. I would think that could be questioned rather frequently.
Madam Chair.
Could you respond?
Sure. Yeah, I mean, you definitely have a subjective element to that. I think if you're going to do anything like this, you probably have to have, it's probably a necessary evil, because you've got to have some determination on a case-by-case basis as far as the safety of this disclosure. But what I would say is that the intent may be to limit this to situations where an investigation is being conducted or has been conducted. However,
It doesn't say that.
it does not say that. It also is not tied to the investigation section in any way. What it does say is that the local department has to disclose, upon request of a guardian, the location of a child when that child is with another guardian, unless it's unsafe.
Madam Chair.
Seems a bit broad. Delegate Leftwich.
I know we don't like to draft bills in committee, but I would view that as a friendly amendment if there's an easy fix to that council can recommend.
Madam Chair.
Senator Reeves.
Delegate Leftwich, so what you're really trying to do is just make sure that the parental rights of each parent is respected. So one parent's not trying to use that child as leverage or to get back at the other parent. Is that the gist of what you're trying to do?
That's a big part of it. But I'm not trying to involve the department in these minor disputes. Really only intend to, if they happen to have the information through an investigation and it's not unsafe, because of privacy laws, they're restricted from giving information. So I think they actually need this if they want to provide that information to an innocent parent.
And Mr. May, I think you mentioned this wasn't drafted in the section where you would normally draft it either. He's got it under confidential records. Oh, dear.
Madam Chair.
Senator Reeves.
If we could just take this by temporarily, we're moving at a pretty good pace. I think David could probably draft something to fit what was there and fix this. So I think it'll be in a little bit better shape for the delegate.
Madam Chair.
I want to take some public comment as well before we
Yes,
send
ma'am.
it that way.
Madam Chair.
Senator Morrissey.
I want to follow up on your point about line 24, beginning with the clause, unless the local department. Was it the chair's position that may be so broad a clause that it would make this legislation either unworkable or essentially null and void? Was that the point that you were getting at?
Well, the point I was getting at is I think it would leave the local department up vulnerable for a lawsuit. I mean, a lot of people could disagree on whether the child was unsafe.
That's exactly correct. Exactly correct. And let me just follow up on that comment, and then perhaps somebody can comment on it. I can see a situation where, if this clause stayed in there, essentially it gives the local department entire veto on whether or not to disclose the location of the child if they simply determine on their own that it may compromise the safety of the child. So if they don't want to disclose, they can essentially say, no, we think this is going to compromise safety of child. We're not going to do that. Delegate Leftwich, are you concerned about that the good intent of this legislation may be voided by that clause?
Senator, right now, I think absolutely prohibited and precluded from disclosing that information. I think this bill gives them discretion, which I think is better than an absolute bar.
And I do worry about the safety of the child as well. Let's hear some comment. I'm not sure that this is going to be such an easy fix.
Madam Chair, I'm sorry, this is M. Parenti again. The
Yes.
other thing that I would say is that the department does not have a mechanism for readily knowing who has custody of the child. So that's the other issue that that we anticipate we'll be running into. If a parent calls us and says they're custodian, they have legal custody, we don't have any way of verifying that immediately.
I think this is a very complicated area. Are there any other speakers? Thank you for that information. Ms. Parenti, are there any other speakers?
Yes, Madam Chair. We have Valerie LaRue. Please go
On
ahead.
this bill?
Good morning, Madam Chair. This is Valerie LaRue from the Virginia Poverty Law Center. And I have been hearing from domestic violence advocates that they're concerned that, that this could be used as a mechanism by which, abusive partners could track down the location of a child and spouse. And so they're concerned about that, and they would be concerned if that was removed from the bill for that reason. I don't have a suggested fix for it, but I know that there is that concern that without having that, if it, the danger of the child in there, that could be used by abusers to track down children and spouses for further abuse.
Yeah, I would agree. Well, colleagues, the bill is before us. I think this is a little bit more complicated than we might think, and perhaps it would benefit from more work and
Madam Chair.
coming back next year.
Madam Chair.
Yes, Senator Mason.
So we were going to either take it by temporarily, see if Mr. May could work on something, or
PBI.
there's been a little bit, I understand your motion, ma'am, but has Mr. May had some time to look at it, and does he think that there's something that could accomplish what we're trying to accomplish here?
Can this be salvaged, or, I remain concerned about the department not having the mechanisms to know.
Well, Madam Chair, if I call and say I don't have my child, then you know who to call and try to find who's got the child. I mean, that's not one person has the child or not.
Right.
So them having the mechanism to figure that out is kind of moot, because I've called and said I'd like to know where my child is. So now they have my spouse's contact that they tried to begin. And to Ms. LaRue's question, there's a phrase in there that says, unless otherwise worried about the safety of the child. So I think her point is addressed in the bill. So I just wonder if Mr. May has something that kind of splits the difference in what we're talking about.
I'm certainly going to ask Mr. May to respond to your comment. But again, the department would have to determine that the person actually asking for the location of the child is truly the parent or guardian. I think that was Ms. Parenti's point. David May.
Madam Chair, Senator Mason. Yeah, so if I was to take a shot at this, what I would do is I'd first move this to section 63.2-1505, which is about the investigations when a local department conducts an investigation. And I'd probably put it down in subsection B, which basically says, if the local department responds to the report or complaint by conducting an investigation, the local department shall. There's a series of various requirements in here. What I would do is tack on to the end of that list a subdivision number 8 that said something along the lines of, and I'm paraphrasing here, but that at the request of a parent or guardian, the local department is to provide the location of the child to the other parent, provided they're not subject to a founded complaint of child abuse or neglect, and provided that it does not compromise the safety of that child or that other guardian.
So Madam Chair, that sounds like what we're all kind of fishing for, but since it changes sections completely, can we take this by for the day and allow the delegate Leftwich to work with council?
Madam Chair?
Thank you, Senator Mason. I was going to suggest we have a meeting next week.
Yes, ma'am.
So if it would be to your liking, Delegate Leftwich, why don't we take this by until next Friday?
I would appreciate that, Madam Chair.
And then
Thank
you can perhaps sit down with the stakeholders and talk to whoever drafted this. I don't know. I guess you did not draft it?
No, I relied on House Counsel to do that.
Sure. Okay.
Thank you, Madam
All right.
Chair.
Everybody in favor of taking it by for the day, we'll pick it up on Friday. All those in favor signify by saying aye. Aye. Okay. Thank you, and hopefully we can come to some.
Thank you, Madam Chair. Thank you, committee.
Delegate Plum, the Children's Services Act, effective monitoring and implementation.
Thank you, Madam Chair, and good morning to you and to members of the committee. House Bill 2212 is a product of a year-long study by JLARC looking at the Children's Services Act. As members are aware, the Children's Services Act provides funding and assistance to local governments who are working with our most vulnerable children, those who have the widest range of needs. What the study found was that we have some amazing programs going on throughout the Commonwealth. We don't spend nearly as much money as some people had feared we have if you compare us with other states. But what we lack is, in fact, though, the ability to monitor what's happening in the localities. And too oftentimes it's maybe the zip code in which a child may live as determines what kind of services they get. What this bill proposes as part of the overall look at the Children's Services Act is that the director of the Office of Children Act be able to monitor programs from local governments. So I hope it'd be the pleasure of the committee to report the bill.
Thank you. Thank you, Delegate Plum. I'm going to ask my colleagues if they have any questions, and then if we have speakers on your bill, I certainly will let them in.
Madam Chair, Stewart in the corner.
Oh, I apologize. Senator Stewart.
Thank you, Madam Chair. Delegate Plum, are you familiar with Senator Mason's bill? I can't remember the name of it, but he had a relatively comprehensive bill that addresses some of the issues that I think you're talking about, and I just want to make sure there's no conflict with your bill and Senator Mason's bill, because there were quite a few of us who joined in with Senator Mason and worked on that, put parts of our bills in it. Maybe staff can answer it if Delegate Plum can't. Sorry, Monty, I didn't see you sitting over there.
No, Madam Chair.
Senator Mason?
Madam Chair, Senator Stewart is correct. We do have a pretty extensive, that is focused mostly on private day. I think Delegate Plum is getting to a really important point here that we often, CSA tends to be a funding mechanism for us. And in places we don't have the local tracking, I don't think that we need. And as he said, you know, unfortunately, it does come down to zip code sometimes as to what services are available to the children. So CSA could, in fact, fund it if there were a mechanism to do so in the area. So I do think this works in concert, a little different than what we were targeting with our CSA effort. But I think a local review in certain areas would, if nothing else, give us an awareness and evaluation of where there are pretty significant holes in services needed, being provided, and that could be funded if we had a mechanism to do so. So I don't think, Madam Chair, they're in conflict, and I think this makes a lot of sense.
Very good. And there are also some data collection elements in here. I think this is a workable bill. Are there speakers? Go ahead, please call them.
Allison Gilbreth, please go ahead.
Madam Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children. We wanted to thank Delegate Plum for bringing this bill forward, and I wanted to share that all 20 members of the Foster Care Unified Agenda are in support of this legislation. Thank you.
Thank you. Are there other speakers?
One final speaker, Madam Chair.
Go ahead.
Tracy Smith, please go ahead.
Thank you, Madam Chair. Tracy Smith from JLARC. I was only here to answer questions if it came up about the JLARC study. And thank Delegate Plum for bringing the bill.
Very good, thank you. Is there a representative from DSS who also wishes to speak?
If so, please raise your hand.
Okay, this bill looks like it's in great shape. Okay,
Madam
great.
Chairman, does it need to go to
This
finance?
has to go to finance, so, okay. Motion has been made to report and re-refer to finance by Senator Mason, seconded by Senator Boysko. Clerk, please open the roll.
Ayes 15, noes 0.
Very good, Delegate Plum, your bill reports unanimously.
Thank you very much, Madam Chair, members of the committee.
Thank you. Okay, so let's get to a couple of bills that are a little more complicated. Let's go to House Bill 1820. The patron is Delegate Helmer, and I believe Delegate Helmer is in the queue.
Can you hear me, Madam Chair?
Yes, we can. Thank you.
Good morning, Madam Chair, members of the committee. House Bill 1820 deals with the fact that we are one of only 7 states out of 50 that hasn't implemented broad-based categorical eligibility for SNAP, also known as food stamps. And as a result, we're missing out on helping more than 25,000 families and 70,000 post-secondary students put food on the table and leaving millions of federal funds out of the Commonwealth. With 1820, we have a rare opportunity to pass a bill that has no downsides and no trade-offs in support of Virginia's people and economy at virtually no cost to the state, all the while creating about $10.5 million in economic activity to help our small businesses. This legislation in front of you, which will implement broad-based categorical eligibility as well as cement the role of higher education and access to TANF, has the support of almost 80 organizations, from food banks to citizen action nonprofits, the American Heart Association, to the Virginia Poverty Law Center. And we are also proud to have the administration's support for this bill. I hope the committee will look favorably upon it. And we have the VPLC, Carrie Welton of the Hope Center, Julia from Virginia 21, and Mark Golden from DSS on the call to answer technical questions, speak in support of anything I can't answer as well.
Thank you, Delegate Helmer. Let's turn to somebody from DSS. I don't know if M. Parente is not, I don't know if this is under her bailiwick. Is there the SNAP administrator from? Tony Watkins. Okay. Are you with us? We don't see Tony in our queue here. Are there other speakers on this bill?
Julia Billingsley, please go ahead.
Good morning, Madam Chair, members of the committee.
Good
Julia
morning.
Billingsley,
Good
Virginia
morning.
21. How are you today?
Fine, thank you.
We strongly support removing barriers for post-secondary students to access TANF and SNAP benefits. Food insecurity is a pressing concern for students financing the high cost of their education and related living costs. And this presents a troubling challenge for degree completion. We thank the patron for addressing this important issue and hope to see the bill pass. Thanks.
Thank you so much.
Chelsea Bennett, please go ahead.
Yes, good morning, Madam Chair and
Good
members
morning.
of the committee. Chelsea Bennett with the American Heart Association. Happy Friday to each of you. Today, we're here to share our support for HB 1820. As you heard from Delegate Helmer, Virginia is one of the few states that does not have BBCE, and we support setting the gross income eligibility standard at 200% of the federal poverty guidelines and eliminating the income and asset test for SNAP. Evidence suggests that BBCE simplifies the application process for potential SNAP participants and reduces administrative costs for state agencies. We continue to support strong nutrition security policies that's going to ensure that nutritious fruits and vegetables are able to be on the tables of all Virginians. Thank you for this opportunity to speak.
Thank you for sharing your thoughts. Next speaker.
Salam Bhatti, please go ahead.
Good morning, Madam Chair. Salam
Good
Bhatti,
morning.
Virginia Poverty Law Center.
I echo what everybody else has said, so I won't repeat that. I do want to let the committee know that the Northwestern Institute for Policy Research estimates that food insecurity has increased in Virginia from 9.4% to 22% as of last year. So these are incredibly concerning times where people are going hungry throughout our state. And with this bill and your votes, we can definitely help get food on the table for so many of our hungry neighbors. We encourage your support for this bill. Thank you.
Thank you.
Those are all our speakers, Madam Chair.
Have you
more speakers, Madam Chair?
Okay, colleagues, the bill is before us. Okay, has to be re-referred to finance. Okay, motion has been made to report the bill and re-refer to finance. Senator McPike made it, Senator Mason seconded. Will the clerk open the roll, please?
Ayes 15, no 0.
Delegate
Thank you,
Helmer,
Madam
your
Chair.
bill
Thank you, members.
reports, and it is re-referred. I understand, I have one smaller bill, and then we're going to go to Delegate Levine's bill, which will be the last bill we take up for the morning. Delegate Campbell, I understand you're in the queue. House Bill 2010.
Please unmute yourself, Delegate.
Good morning, Madam Chair. Can you hear me now?
Yes, good morning.
Thank you, and thank members of the committee. House Bill 2010 is simply an attempt at a cleanup from last year's earned sentence credits reforms that were enacted by the General Assembly. Like many of you, I'm sure when I got back to district, I received a number of calls about the application of that measure. And in the course of addressing those constituent concerns, it became apparent to me that there were some ambiguous language with respect to certain classes of offenders, in particular, those offenders who were serving a suspended sentence for those enumerated felonies under subsection A, who were subsequently back before the court on a probation violation. As a result, we brought this bill to try to clean up that and more accurately espouse the policy of the General Assembly with respect to those offenders. I hope it be the pleasure of the committee to act favorably upon it.
Thank you, Delegate Campbell. If I'm reading your bill correctly, it really just is clarification. Is that correct?
That's correct, Madam Chair.
Okay.
Madam Chair, just to
Yes, Senator Boysko, you worked on a Senate version of the
yes, ma'am.
sentence bill.
I would just like to just clarify with our council, just to make sure that this is purely just reiterating what's already in the bill.
Mr. May.
Madam Chair, Senator Boysko. Yeah, if anything is a clarification, I really don't know that it does anything at all. Maybe the original version possibly provided some more clarification. So yeah, I don't think there's any intent or effect of shifting the policy of what this actually does. Doesn't cause any harm.
Thank you, Madam Chair.
Thank you, Senator Boysko. Is there another question?
Madam Chair, if I could speak to
Yes.
council comments.
Delegate Campbell.
And I would fully agree with council. I think the original version of the bill was a little more accurate with addressing the concern. The change in language came through the committee, House committee actually, and was suggested by council in the House. I do believe that it probably just reiterates the same ambiguity with the way it is currently. I think the original version was a little more clear in that regard.
Madam Chair.
Senator Morrissey.
Thank you. Delegate Campbell, was there a particular case that arose that caused you to make this change?
Senator Morrissey, members of the committee, no, there was not a particular case. It was actually a couple of cases, not involving me as an attorney, just simply being consulted as a delegate about the application of this bill going forward with respect to family members of constituents who were actually incarcerated at the time. and one in particular was out on a suspended sentence and had subsequently been violated under 192306. And those of you that do criminal law know that those charges are brought under that code section. And the law as we passed it doesn't seem to address those classes of individuals. And this was simply an attempt to try to clarify and espouse the same policy we passed last year to these classes of offenders if they happen to be subsequently back before the court on a probation violation, on a suspended.
Follow-up question. So you're not aware of any situation where a defendant who was released from incarceration, then had a show cause hearing where his sentence was revoked, did not get the earned sentence credits that we worked on in the Senate?
Senator Morrissey, members of the committee, no, I'm not aware of that yet. Obviously, the bill actually has a delayed enactment date to July 1 of 2022. So the earned sentence credits program actually has not yet been implemented.
All right, thank you, Madam Chair.
Thank you, Senator Morrissey. Any other questions, colleagues? The bills
Madam Chair,
before
I'd
us.
move to report.
Senator Boysko moves to report, and it was seconded by Senator Mason. Will the clerk please open the roll?
Ayes 15, no 0.
Thank you, Madam Chair.
Delegate Campbell, your bill reports. Okay, so I believe Delegate Levine's is the last bill that we have to hear. Is that correct, Mr. May? Okay. Delegate Levine, are you in the queue? This House bill, colleagues, please turn your attention to House Bill 1932.
Hello?
Delegate Levine? Oh, dear. Does he have to connect? Delegate Levine, can you try to speak to us? Oh, he's in House Public Safety. You may want to text him. Yeah. Okay, colleagues, we're going to have a 5-minute recess until we can get a hold of Mr. Levine and get him connected to the Zoom call. The Rehab and Social Services Committee will now be called to order again. Will the clerk please open the, oh, do we need to open the roll? Okay, because we were just on recess? Okay. All right, the bill before us is House Bill 1932. It is Delegate Levine's bill. Delegate Levine, welcome. Would you please present your bill?
Thank you, Madam Chair, members of the committee. I apologize. I literally had to be in two places at the same time, so I apologize for being a little late here. HB 1932 is a bill to repeal a law that was passed in 2012. And the law in 2012 requires Virginia to license and fund child placement agencies that discriminate against Virginians on the basis of religion. What the current law does, it says that if you have an agency that refuses to place children in families because of the family's religion or because of the family's sexual orientation, or really based on any religious tenets they have, they can refuse to replace that child, and that Virginia must not only license that agency, they must fund that agency. Now, prior to 2012, such agencies existed and were licensed in Virginia and certainly were around. But the 2012 bill is the first and one of the few places in the Virginia Code where religious discrimination is not only permitted, but required by law. My bill repeals that. And it's important to note that there are a lot of children in Virginia that need a home. Virginia, unfortunately, is down at the bottom, 48th or 49th, in placing foster kids. And the foster kids that are most difficult to place are the ones, frankly, who have disabilities, mental or physical disabilities, or perhaps they've had some trouble with the law. And there are families ready, willing, and open to take these kids. And actually, gay families are 7 times more likely, statistics show, to take some of these kids that are hard to place than straight families. And so when you lessen the pool of available families, you are making kids more likely to age out of the system. And another thing that should be of note is that some 20% of children in our foster care system are gay or transgender. And you might ask, why would that be the case? And the answer is there are parents who kick the kids out of their homes for being gay or transgender. And so these kids are already feeling pretty unloved by their parents. They've been kicked out of their home for no fault of their own. And then to have a placement agency say, oh, sorry, we also don't think you're good enough to have a family, or we don't think this family is good enough to have you, and we're going to place you with a family that hates the fact that you're gay, just like your other family. Well, then I have to get into the question of why some 40% of LGBT youth have considered suicide. And in fact, kids that are kicked out of their families are 8.4 more times likely to choose suicide. So this is really a very dangerous practice. It's a very dangerous practice to children. And again, the bill is actually fairly modest. All it does is repeal the requirement that Virginia license and fund these agencies. It doesn't actually prevent Virginia from licensing and funding these agencies as they did prior to 2012, but it says it's no longer required. And with that, Madam Chair, I know there are a number of people who want to speak to the bill.
Thank you. Thank you, Delegate Levine. I know that some members have questions, and before I get to speakers, I'm going to allow our members to ask you questions. And I believe one of our committee members will have a amendment to your bill, and we would like to discuss that before we take public comment. So, colleagues, do you have any questions you would like to ask Delegate Levine at this time? Senator McPike.
Thank you, Madam Chair. First, I'd like to thank the delegate for his work. I think he's identified some really important things that are in our existing code that clearly have a difficult sort of moral framework that I think is before this committee to deal with. One of which is religious freedom. The other is discrimination. Having said that, taking a look, I know one of the concerns is how to provide the appropriate response to faith-based organizations to provide service, which they do today. And as I think the delegate rightly pointed out, there are a number of different agencies that within the faith framework do a considerable amount of good work. However, the practice of having policies or procedures that discriminate are difficult to reconcile when we use taxpayer dollars. And I think the existing code under 63.2, 1709.3, Section C specifically state that the state and local agency cannot deny a child placing agency any grant or contract. And so that whole section basically lists out a government endorsement and use of taxpayer dollars to discriminate. And I think, to me, at the core, that is wrong. Having worked with stakeholders over discussions over the last several days, I've also heard concern from the faith-based organizations that they also do not want to lose the ability to have a licensure while also protecting their faith-based arrangements and to being able to apply that faith consistently in the application of that license. Through the discussion and collaboration with colleagues also, there's concern that this section does not have any sort of re-referral requirement should they use the conscious clause as outlined in the bill. And so, Madam Chair, I'd offer substitute number 2 to the committee, which begins to address some of those concerns. It would include, and if council can provide substitute 2 and load that to LIS, that would be helpful.
I'd like to move substitute number 2.
All those in favor signify by saying aye.
Aye.
Okay, let's go to substitute number 2 on your iPad. Mine says posting in progress.
We'll give it a moment, Madam Chair, but I'll be happy to describe some of the elements.
Why don't you go ahead?
It would add to Section A basically provisions for a child placing agency that refuses to perform or assist in such placements of a person seeking adoption or foster care services, that child placing agency would need to immediately provide those persons with a list of approved agency placement agencies, and the specific language on the online, that way it's the most up-to-date on the Department of Social Services website. And in a moment, I also will defer to my colleague, Senator Mason, on a few thoughts on that. Furthermore, Madam Chair, as you can see, the substitute would delete Section C from the code, and that is the section which deals with the use of taxpayer dollars in that discrimination framework. I think this is an important point to remove that conflict and remove that section while still preserving under Section B a faith-based organization's ability to gain licensure within the state. Furthermore, the enactment included in the substitute would delay the removal of Section C until July 1 of 2022 for the sole purpose of 2 things, Madam Chair, one of which is we know that there's a Supreme Court case pending, Fulton versus City of Philadelphia. Additionally, this gives time for DSS and the department to evaluate transitions and also have discussions with those existing faith-based providers in terms of whether or not they're going to continue to participate without grants. And I think that's a choice that those organizations need to make. My personal belief is that the practice of denying service is one that is wrong. It is not in the teachings of faith that I grew up and I was taught in my own Catholic faith. However, I understand there are organizations that wish to do so within their faith guidance. And so I'm also double checking to see if the substitute is now up as well. Okay.
Is it up? I don't, let's see.
Yeah, if you refresh, it's now up. So you can see sort of the lines 14 through 18 are added to Section A. Lines 23 through 26, remove section C from our code. And then lines 30 through 31 have the delayed enactment of the implementation of the removal of section C by July 1 of 2022, Madam Chair. And I do understand that the patron, having provided this draft, is not in favor of this substitute. However, I do believe, after talking with stakeholders, that it does get to one of the core hearts of the matter, which is taxpayer funds and grants essentially being provided to those organizations that do use the conscious clause provisions. I'll be happy to answer any questions on this.
I am going to ask the patron to respond to the proposed substitute.
Thank you, Madam Chair. I do think it is an improvement to remove taxpayer-funded religious discrimination, and so I certainly support the removal of Section C.
Thank you.
I do not think it goes far enough because we still have religious discrimination in the code, and we still have children being shuttled from place to place who are already rejected by their families, being rejected yet again, and loving gay families not able to take in those kids and adopt them and give them the warm home they want without them being shuttled from place to place. So I don't think it goes far enough, but it is a step forward.
Madam Chair. Joe.
Senator Morrissey.
To the patron, first of all, Delegate Levine, I want to thank you for the legislation. Even though it's a very short piece of legislation, you have done a tremendous amount of work. You have spoken to so many stakeholders and agencies. You've reached out to so many legislators and provided us with materials. Most importantly, you have drilled down the confluence of faith-based discrimination and the use of taxpayer dollars, and I applaud you for the legislation, full stop. With that said, tell me why Senator McPike's legislation doesn't, although maybe not go the full measure to what you want, tell us why it's not moving us forward and it doesn't get us to a much better place than we are now.
Madam Chairman, Senator Morrissey, I agree that the amendment is a step forward. I'm not saying it's not a step forward. I think it is a step forward. So that's undisputed. I do think it leaves in our code, and maybe I can come back at a future day, but it leaves in our code the ability for some pretty awful organizations, not the ones, frankly, that have called you about this bill, but in our code, we would have to license and say no damages for child placement agencies that could discriminate against people on the basis of their religion or even their race. In South Carolina, by the way, this exact same statute was used to fund state funding, that was state funding, but a child placement organization that refused to place families with Jewish families. They said Jewish families weren't good enough to adopt children. It was a Christian child placement agencies. Jewish families couldn't adopt children. And unfortunately, there are even religious organizations that are blatantly racist. I can name a few of them. Christian Identity Movement is one of them, or even the Ku Klux Klan claims to be a religious organization that could say, you know what, we don't put kids in this family based on race. And this statute would say, well, you know, we've got to license them. We got to license them. There's no prohibition. That's their religious base that they believe in this discrimination. So we've got to license them, and there are no damages either.
Madam Chair,
Senator.
I've listened to a lot of facts come out of here, and I'd like the patron to cite his source on the South Carolina case he's referring to, please.
Sure, I'll be happy to. I'm going to go do a quick Google search. I have to find it.
I will just say emotions are high on this bill. Let's just make sure our tone is always polite and professional.
Madam Chair. Madam Chair.
But it does a step forward, no question about it.
Back corner.
Oh, Senator Stewart.
While he's looking, and I don't know if it's a question for staff, but in fact, do religious organizations in Virginia discriminate based upon race with placing children? If they do, I'd like to know about that, and I'd like to know which ones are doing it. Is there someone who has an answer?
That would be a question for M. Prente, who I believe is on the line. M, if you're available to respond to that question while Delegate Levine is doing some research.
Madam Chair, members of the committee, this is M. Parenti with the department. We're locally administered, state supervised, and there are many LCPAs across the state. Our goal is to have a diverse pool of foster families because we have a diverse group of children in foster care. Delegate Levine spoke to the additional children who identify as LGBTQ compared to the general population who are in foster care. We also have children of lots of different religious backgrounds and races. And our goal is to try to place children with families that will meet their needs. So having a diverse pool in both the local department approved homes and the LCPA approved homes increases the likelihood that we'll find a family that will meet the child's needs. We don't place based on race, and our local departments don't place based on race, but we do try to place kids with families that we believe have the ability to meet their needs.
Madam Chair, I've done my research when you're ready.
So the simple answer was no. If I understood her response, the answer is no.
I would say that's a fair interpretation. Would you say that, Ms. Parente?
The regulations actually prohibit the LCPAs from discriminating based on race.
Thank you, Madam Chair.
Flat-out answer.
And Madam Chair.
Thank you, Senator Mason.
Speaking of the substitute, so Madam Chair, this is a very difficult one because, many of us in here have 100% of the time voted for equality at every step of the way. In fact, last night in discussion with someone that I admire and respect a great deal, we talked about being inclusive of all races, religions, abilities, and identities. And that's super important. And you heard Ms. Parente just say right there, we work very hard to place children in situations that are good for them. So I really appreciate Senator McPike's work here. And as the patron said, it's an improvement because it takes out C. I would like to go a bit further in that if my partner and I walk into a adoption or a foster care placement agency and we're not a good fit for their religious beliefs, Senator McPike's substitute requires that they offer a list of other options. I'd like to go it a step further, and I'd like to amend that substitute to make sure that with permission of the couple, that their contact information and that their information and their contact information are provided to social services to make sure that social services can reach out to them so they not only have a list, but they are going to be contacted by social services to try to match them in places that are in keeping, just match them, period. Because one thing that's concerned me from the start, when the patron talked about, we're 48 and we're limited. In an earlier debate when Senator Boyce goes bill, I was maybe a bit too sharp with a gentleman because I perceived the direction to be discriminatory. We have 700 or 800 kids placing out of foster care a year. And to me, to limit an agency that is currently providing services, if 25 couples walk into a religious organization and adopt 25 or foster 25 kids this year, I do not want to do anything to stand in the way of placing those children. I am loath to suggest that the state support discrimination, which is why I think Senator Pike's Section C is very, very important. But I do think that this would, in lieu of the court case, give us another year to have them operational, remove Section C, which suggests that contracts could go to these folks. But at the same time, keep them operational and placing children in foster care where it matches. And so, Madam Chair, I apologize for the long diatribe there, but I'd like to ask council if we can add to the substitute an amendment that suggests that the contact, with permission from the couple, if the contact information can be immediately as provided to DSS so that they can have another mechanism to reach out to this couple and try to match them with a child as soon as humanly possible.
Okay, Senator Mason, I am going to ask David May to craft that sentence, and when we hear the sentence, I will ask for a motion and a second for to adopt it. I do think that is an important line amendment because so often when individuals have to be re-referred, that's another barrier to bringing them into the fold of perhaps becoming a foster family. And we want to make it as easy and as welcoming as possible for families to adopt children or to foster children. So I'll ask Mr. Mays. I was taking some airtime so you could.
Madam Chair?
Are you ready? Before I call on you, Senator Spruill, let me ask
Yes, ma'am.
David May to read the line amendment.
Madam Chair, Senator Mason, yeah, I've drawn up something. I guess the easiest way is probably I'll just read through how the entire new sentence would look. I just added into the existing sentence that we're already adding. If a private child placing agency refuses to perform, assist, counsel, recommend, consent to, refer, or participate in the placement of a child for foster care or adoption on the basis that the proposed placement would violate the child placing agency's written religious or moral convictions or policies, the child placing agency shall immediately, 1, direct the person seeking services to the online directory of licensed child placing agencies maintained by the department, and 2, provide the name and contact information of the person seeking services to the department, provided the person seeking services consents to such disclosure.
Okay. Colleagues, you've now heard.
I move that amendment, Madam Chair.
Motion has been made by Senator Mason, seconded by Senator Cosgrove. All those in favor of the amendment signify by saying aye.
Madam Chair, you made a motion on it. My question was on the amendment that we were talking about. I wanted to know as the patron, how did he feel about it? You got a vote already. I haven't even had a chance to ask the patron, how did he feel about the amendment that was put in by the senator?
Oh, Senator Spruill, we did have a conversation with the patron. You perhaps were out of the room, but
I'm talking about the one that Senator Mason just got through doing. The one you
Okay,
just got to on that one.
let's talk about that. Delegate Levine.
Thank you, Madam Chair. I would briefly say that I do think Senator Mason's amendment improves Senator McPike's amendment. I still have some difficulties overall. I don't think it goes far enough. And I do have the information that was asked for about South Carolina discrimination against Jewish families. But for the sole purpose of saying that I support Mason's amendment to McPike's amendment, I do.
Thank you. Do you have a response on the South Carolina data?
I do, Madam Chair, and I should note that I didn't say that any agency in Virginia discriminates on the basis of race. I said the law would allow that, but it doesn't happen to my knowledge. And to my knowledge, there's only one charity in all of Virginia that takes taxpayer funds and discriminates, and they discriminate on the basis of sex orientation, not race. The South Carolina case is the case of Miracle Hill Ministries in Greenville, South Carolina. And my citation is to the Associated Press on January 24th, 2019. And what happened is the federal government agreed to allow federally funded foster agencies in South Carolina to deny services to same-sex couples and to non-Christian couples. And so this was a state-funded, South Carolina-funded agency that would not place foster children with Jewish couples in South Carolina. A regulation from President Obama would have prohibited that, but President Trump undid that regulation and allowed that discrimination to occur. And again, it's the AP January 24th, 2019, and Miracle Hill Ministries in Greenville, South Carolina.
Thank you, Delegate Levine. At this time, colleagues, I'm going to go to speakers. We do have some. Will the clerk please tell us how many speakers?
Madam Chair, we have 18 speakers.
I'm sorry?
18.
18. I'm going to ask each speaker to keep comments to a minute or less. We appreciate you being with us, and we look forward to hearing your remarks. Will the clerk please call the first speaker?
Yes, Madam Chair. Our first speaker is Allison Gilbreth. Please go ahead.
Madam Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children. We want to thank Delegate Levine for bringing this bill forward. Thank you to Senator McPike and Senator Mason for their substitutions today. We are in support of those. We want to reiterate that Virginia continues to rank 49th in the country for youth aging out of foster care. We have a disproportionate number of youth who identify as LGBTQ+, and we want to ensure that those children and other children have families and homes that will meet their needs. And for those reasons, we support this bill. Thank you.
Thank you. At this time, anybody who has signed up to speak will be allowed to speak. Folks that are signing up after 10 o'clock, I apologize, but we will not be taking your comments. Will the clerk please call the next speaker?
We have Valerie LaRue. Please go ahead.
Thank you. Madam Chair and members of the committee, this is Valerie LaRue from Virginia Poverty Law Center. And for the reasons already stated by Ms. Gilbreth, we also support this bill.
Thank you.
V. Lamneck, please go ahead. V. Lamneck.
Good morning, Madam Chair, members of the committee.
Good morning.
Good morning. My name is V. Lamneck. I'm the Executive Director of Equality Virginia. We're the Commonwealth's leading organization advocating for LGBTQ equality. And we do support this bill with the substitute. I will say that we are disappointed that we are not moving forward with the full repeal because, in effect, we would still have discrimination on the books. When you look at the historical discrimination of LGBT people in our country, it's counterproductive to have a message still in the books that it's okay to discriminate. This is a step forward, but the state is still essentially sending the message that LGBT families are not welcome. I know that it takes courage to foster and adopt, and it's confusing for families who want to adopt and foster to know if they're able to do so with the conscience clause still in the books. Again, the substitute is a step forward, but it is simply not best practice. Sends a mixed message where, in effect, we actually need to be rolling out the welcome mat for all LGBT families.
Thank you so much for your comments.
Thank you.
Clerk, call the next speaker.
Elizabeth Fogarty, please go ahead.
Good morning, Madam Chair and members of the committee. I'm Elizabeth from Arlington, and I'm here in support of HB 1932. For over 10 years, I've been a facilitator for the Arlington PFLAG Community Group, a monthly support group for parents with children who are lesbian, gay, bisexual, transgender. And one common theme for all parents is the hope that our children will one day become parents and that we will one day become grandparents. For 10 years, I have been hearing this concern, and I admit it's one that I share. I'm the mother of a kind, thoughtful, loving, smart, responsible daughter who's lesbian. She's a lifelong Virginian. She and her partner will be wonderful parents one day, and we will be wonderful grandparents. And I say that it is time for legislation to stop causing pain and to bring more fairness into the world. As taxpaying Virginians, we sincerely hope and expect that our tax dollars will not be used to deny our children the right to become foster parents or adoptive parents. We sincerely hope and expect that our tax dollars will not be used to prevent us from becoming grandparents. The substitute is a little like separate but equal to me, but I don't have all.
Thank you, Ms. Fogarty. You've gone over time, but we do get your message, and we thank you for being with us.
Thank you.
Ray Ratka, please go ahead.
Madam Chair, thanks for the minute. I am Ray Radke. That's okay. I am CEO of Encircle, formerly Lutheran Family Services of Virginia. We are a 132-year-old nonprofit organization affiliated with the Evangelical Lutheran Church in America. Our organization was founded on beliefs and values inherited in the Lutheran Church with the mission of helping to make the world a more loving place. Based on this mission, and because we believe that this bill will help Virginia align with best practices in child welfare, we support HB 1932. Simply, we believe it is wrong to discriminate against parents who are otherwise qualified to provide loving homes simply because of their identity. Further, we believe Virginia should not use public funds to support a service that discriminates against those who are LGBTQ. Thank you for your time, and thanks for all that you do to improve the lives and children, families in Virginia.
Thank you for being with us. Appreciate your remarks.
Jeff Caruso, please go ahead.
Thank you, Madam Chair and members of the committee. Jeff Caruso with the Virginia Catholic Conference. Our Catholic child placing agencies, which serve people of all faiths, rely on the current conscience protections. We strongly support the current law, but if any legislation does advance, it is absolutely essential that it continue to include the protection for licensing. In 2011, groups, including one or more who testified today, made a push at the State Board of Social Services to end licensure for agencies with our beliefs about marriage. After months of debate, proposed regulations that would have driven our agencies out of foster care and adoption altogether even came to a vote, but were not adopted. Because of this attempt in 2011 to end licensure for agencies like ours and concern there could well be future attempts like it, the General Assembly enacted the Conscience Protection Law in 2012. This ensures that diverse providers with diverse beliefs can continue to help children. If this law is repealed, groups that pushed for the Board of Social Services to take away our licensing 10 years ago would very likely push for that again. The current law is all that prevents them from pursuing that goal. Preserve faith-based agencies. They are an essential part of the community. They are an indispensable part of the solution. Thank you.
Thank you. You
Madam
gave
Chair.
us a lot of information in 1 minute. Excuse me, Jeff.
Madam Chair, do you want to take all of the statements before the members ask questions of individuals, or do you want us to pose questions after?
Do you have a specific
I do.
question to this individual? Okay.
Thank you.
I don't want a long back and forth, but go ahead and ask this individual a question.
Just a couple of questions. Good morning, Jeff. Good morning, Mr. Caruso. How are you?
Good morning, Senator Morrissey. Good morning, Madam Chair.
Good morning.
Jeff, can you explain to the members what is the basis or logic behind the Catholic Church or the Catholic Diocese of Richmond's religious or moral convictions that gay parents cannot provide stellar parenting skills?
We respect the dignity of every person. We also adhere to the belief that marriage is the union of one man and one woman, and we adhere to that in our adoption and our foster care practices.
Brief follow-up.
Senator Morrissey.
So you do not, notwithstanding that moral conviction, which we respect, you do not deny that gay couple can provide stellar parenting skills?
Madam Chair, Senator Morrissey, thank you for the question. Our belief about marriage is that there's a complementarity between one man and one woman, and the ideal situation for parenting would be being parented by a mother and a father, while recognizing that that does not happen in every case, certainly.
Thank you, Jeff. Thank you, Madam Chair.
Thank you, Senator Morrissey. Let's go on with our next speaker.
Madam Chair, I'm sorry. Could I ask a question of Mr. Caruso as well?
Senator Stewart. Mr. Caruso, would you come back into the Zoom?
Yes, Madam Chair.
Thank you. Mr. Caruso, I just, for my own information, how many of these how many children are these faith-based organizations able to place in Virginia currently? What's the average number in a year?
Madam Chair, Senator Stewart, thank you for the question. The totals that I have, and these are totals from Catholic agencies. So we have 3 Catholic Charities agencies in Virginia: Arlington, Commonwealth, and Eastern Virginia. And then also from Barry Robinson Center, which is Catholic affiliated, and several other organizations. And the totals that I have are within the last year or two, 210 for foster care, 306 for adoption, 444 for pre-adoption, and 1,004 for post-adoption services.
Thank you.
Thank you, Mr.
Madam
Caruso.
Chair, one follow-up if I may.
Senator Stewart.
Thank you, Madam Chair. those are substantial numbers. Could you tell me and the committee what impact would Delegate Levine's bill have on that if the bill was passed the way it is, and what impact would the substitute crafted by Senator McPike with Senator Mason's help have on your ability to do those kind of placements?
Madam Chair, Senator Stewart, members of the committee, the impact of the original bill would be to completely nullify all of the conscience protections. So the original bill says that has specific protections for licensing, for state funding, and for liability. If you go with the original bill, that takes away every single one of those protections, including the most fundamental one to us, which is the licensing. If you go with the substitute bill, that takes away the protection specifically for the state funding, and there are several agencies that do have some state grants and contracts. One of them is for treatment foster care. There's one for post-adoption services.
Madam Chair, I'd hate to cut Mr. Caruso off. I understand what each bill does. I understand what the original does. I understand what the substitute does. What I really want to know is what will the impact be on the agencies? It sounds like to me if the bill is passed in its original form, it'll shut these faith-based agencies down. What impact does the substitute have on the faith-based agencies doing these placements?
I think he's looking for a comparison, Mr. Caruso.
Yes, Madam Chair. So yes, to the first point, yes, correct. It would place all private faith-based agencies that adhere to the conscience law in serious jeopardy of even maintaining their licensure. For the substitute, the specific impact would be on the state funding component. So they're only.
Yeah. Okay, Senator Stewart, I think we need to move on to other speakers. Thank you, Mr. Caruso. The clerk, please call the next speaker.
Yes, Madam Chair. We have Rebecca Hall. Please go ahead.
Good morning, Madam Chair, members of the committee. Thank you for giving me the opportunity to speak in opposition to HB 1932. My name is Rebecca Hall. I'm the Director of Adoption and Child Welfare with Catholic Charities of Eastern Virginia, serving adoptive children and families. I strongly oppose the repeal of the conscience protection law as it brings with it a ripple effect of unknown questions and consequences. And this would be the original HB 1932, not the amendment. Foster and adopted children come with trauma. That trauma does not end the day that the final order of adoption is signed and they find permanency. I know this better than most. As an adoptee, I am one of those children. CCEVA has a comprehensive post-adoption program, which in order to have requires us to have a license and is funded through the VDSS. In the past 3 years, we have provided services directly to 112 children and close to 200 children indirectly through trainings and conferences provided to their parents. 95% of these children have been adopted through the foster care system. If HB 1932 were passed in its original form, we would be in jeopardy of losing the funding for this program and would impact our agency's ability to provide long-term support for these children and families and help ensure that their adoptive placements thrive and these children do not end up back in the foster care system.
Thank you. I thank you so much for your comments. Your time has elapsed. Clerk, please call the next speaker.
Chris Seaton, please go ahead.
Good morning. My name is Chris Seaton. I'm the director of Project Belong. Our vision is built around engaging local churches to step in and serve vulnerable children. And I'd like to urge you not to support House Bill 1932. I'm actually amazed at how little Virginia's faith community knows about our vulnerable children. And so Project Belong is a bridge to help churches get involved on every level. You know that the institution of the church has a very wide range of theologies, views, and cultures, but we don't start with our differences. We start with the need and the goal, which is caring for the children. Less than 15% of foster and adoptive agencies in Virginia are faith-based. The other 85% of agencies are not faith-based.
both types of agencies have important guiding principles, and there's room for everyone. Frankly, there's room for more because the problem is large. We need everyone at the table together, pitching in to contribute to the solutions in spite of our differences. Friends, please do not support. Everyone can work together. Thank you.
Thank you. Clerk, please call the next speaker.
Amanda Silcox, please go ahead.
Morning, Madam Chair. Amanda Silcox with Rise for Youth. With the bill and urge you to do so as well. We simply want more children to be placed with more families, which will create better outcomes for kids.
Thank you, Amanda. Clerk calls the next speaker, please.
Anthony Mathenia, please go ahead.
Hi there. Thank you, Madam Chair and members of the committee. My name is Anthony Mathenia. I live in Montgomery County in the New River Valley, and I'm here to encourage you to object this House Bill 1932. Parents, families, and others are certainly affected by it, but it's the children who are the ultimate victims, and they will suffer if it passes. The Old Dominion does not have a history of discriminating on religious and moral grounds, but as written, this is discriminatory to faith-based agencies. I understand the nature of traditional party lines with regard to these types of issues, but surely the children of the Commonwealth are worth us refusing to bow to our usual political ideologies. I have personal preferences. I have unavoidable biases with regard to religion and morality, but do our children not matter more than our personal desires? I've adopted multiple children, some from faith-based agencies, others from non-faith-based. I enjoyed working with all of the organizations, and Virginia benefits from offering these services to the entirety of our population.
Thank you so much.
Children growing up.
Could you conclude your thought, please?
Yes, just children growing up in loving homes and families rather than as orphans or wards of the state provides a more promising future for our Commonwealth.
Thank you for joining us.
Thank you.
Please call the next speaker.
Jed Metafind, please go ahead.
Good morning, Madam Chair and members. My name is Jed Metafind. I'm a
Morning.
foster and adoptive parent, and I also serve as president of an alliance of 200 faith-based nonprofits serving vulnerable children and families nationwide. I oppose HB 1932, but I want to convey respect to the people supporting it. They desire to protect the dignity of all people. We believe there should be a clear, dignified pathway for any qualified person to foster or adopt in Virginia. And I believe that is currently the case. But if it is not, I would be glad to work with anyone to ensure that such a pathway is clear and respectful to all. This bill, however, does not create such a path. In fact, it does not create any new paths for children to reach families. If anything, it would close some existing paths. We do need to clarify one thing also. No agency is currently paid to discriminate. An agency actually gives up its chance for a placement payment when it refers to another agency. But here is the good news. This is an agency
to ask you to
where we
conclude.
can work together to serve the 5,000 children in our foster system.
Thank you so much. Clerk, please call the next speaker.
Mary Rowe Miller, please go ahead.
Good morning. I am a resident of Fairfax County, and I'm co-director of state policy for family equality. We co-chair the Every Child Deserves a Family campaign, which is a coalition of over 700 individual, state, and national partners in the faith, child welfare, and civil rights communities who support the best interest of children by advocating their access to loving and stable placements at home. I speak in support of the original bill of HB 1932. I have some significant concerns with the amendments as suggested because they still leave discrimination on the books, which, as Equality Virginia explained, is detrimental to our LGBTQ families who seek to foster and adopt. And referrals also do not solve the problem of discriminating against kinship and allowing agencies to leave a child in group care rather than placing that child with or license. My time is up. Thank you.
Thank you so much for joining us. Will the clerk please call the next speaker?
Mary Boo, please go ahead.
Good morning. I'm Mary Boo, Director of the North American Council on Adoptable Children, a nonprofit that works to ensure children have families. We have members across the U.S., including in Virginia, and I grew up in Alexandria. We strongly support the original version of HB 1932, which would prevent discrimination against qualified parents. Allowing some agencies to discriminate sends a strong message to prospective parents and the LGBTQ youth that they are not good enough. The bill would increase children's chances of finding a family. Bills like this focus on the best interests of children, not the needs of agencies. Some fear the change will result in moves for children, but that's not what's happened elsewhere when things have gone this way. No child had to move to a new family in Massachusetts. All cases and families transferred to another contracted agency. In other jurisdictions, other faith-based agencies that don't discriminate stepped up to do the work. Passing this bill will increase children's access to placements with families and will not have an adverse effect on children who currently have family placements.
Thank you for your succinct and passionate comment. Clerk, please call the next speaker.
Yes, Madam Chair, we have Robert McCartney. Please go ahead.
Thank you, Madam Chairman and the Senate Committee. I'm Rob McCartney. I'm the CEO for the Barry Robinson Center. We are a child placing agency. We currently have 29 certified homes that represent 83 beds and currently 34 children that are placed in that. This bill would prevent us from getting reimbursed, and then subsequently we would have to close those beds, transfer foster parents to other agencies. I think that all of us know the history that faith-based organizations have played in the providing of social services and care to those who are in the most need. We're very much aligned as a nonprofit faith-based agency of putting children's needs first. And I would think consideration is what takes the place. If the faith-based programs leave the foster care arena, who steps in? Thank you for giving me time to talk. Very difficult decision for you guys.
Thank you.
Renee
Thank you
Lewis.
for joining us. The clerk, please call the next speaker.
Renee Lewis, please go ahead.
Good morning, Madam Chair. I'm Renee Lewis. My husband Brian and I founded a Christian placing agency that has been headquartered in Virginia for over 25 years. I'm also the mother of 5 children, 4 by intercountry adoption. We founded this agency to help other couples like us who believe that all orphan and vulnerable children should have the opportunity to be in a Christian family. I ask you to please oppose HB 1932. There are 159 private child placing agencies and 121 individual branches of DSS throughout Virginia that offer foster care and adoption services, already serving families from all backgrounds and beliefs throughout the state. Protecting faith-based adoption and foster care providers does not interfere with other agencies serving clients of other faith backgrounds and beliefs. Our agency places orphan children into loving Christian families, but we especially advocate for children who are hard to place, like teens and children with urgent medical and special needs, including threatening heart defects, HIV, lower limb paralysis, things of this nature. And we've completed thousands of adoptions in Virginia and all across the US without state funding. I urge you to oppose HB 1932, which would repeal the Conscience Clause and provides our agency with the protections we need to fulfill our mission.
Thank you for joining us this morning. Will the clerk please call the next speaker?
Yes, Madam Chair, we have Monique and Aaron Ransom. Please go ahead.
Good morning, and thank you for having us.
Good morning.
I am Monique, and this is my husband, Aaron. We are adoptive and foster parents. Our 2 oldest kids are adopted. We currently have 1 biological child, and we are foster parents to 2 foster children, 1 whom we are currently moving towards adoption.
And we, went through a Christian agency, our first adoption. And it was huge for us as Christians and believers of having the support of a Christian agency that had the same vision and purpose as we did.
So we strongly oppose the original bill.
Okay, thank you. Thank you for joining us, and thank you for your compassion. Will the clerk please call the next speaker?
Yes, Madam Chair, we have Alexis Johnson. Please go ahead.
Good morning, Madam Chair and members of the committee. We have adopted 5 children
2 locally as infants, 1 from foster care, 1 from South Korea, and 1 from Taiwan. 4 of our children were adopted with moderate to severe special needs. We chose agencies that aligned with our religious preferences because we felt this would enable us to feel comfortable and best understood. Both the home study and the post-placement processes are very personal and require adoptive parents to openly discuss personal details about their lives and families. Faith-based agencies are important in Virginia because they help adoptive families with the same religious faith feel more comfortable with this level of openness and intimacy. Thank you.
Thank you. Thank you for your wonderful work.
Thank you.
Patricia
Will the clerk
Logue.
please call the next speaker?
Patricia Logue, please go ahead. Please unmute yourself.
This is Tricia Logue.
Thank you, Madam Speaker. The decision
That's okay.
made
I'm just Madam Chair, but I appreciate the promotion, but welcome.
Thanks. I am an adoptee, and I also spend time working with pregnant women in need. The decision made by a birth mother to place her child for adoption is one of the most tremendous acts of selflessness and courage that a woman can make. Birth mothers often turn to their faith to help them summon this courage and entrust their child to another family. Adoptions also occur when a mother is most vulnerable, after labor and delivery. It is a time of both trauma and loss, when it's quite natural to turn to one's faith for strength. House Bill 1932 will not change the practices of the adoption agencies that use their faith to inform their service to others. It will simply force them to close their doors if passed without amendment. Please do not deny these brave women, these birth mothers, the opportunity to place their child for adoption through a faith-based process.
Thank you for your comments. Clerk, please call the next speaker. We've concluded? Okay. All right, colleagues. House Bill 1932, as amended, is before us. Are there questions, or we did not hear an answer, I think. Was it Senator DeSteph? I believe Delegate Levine did respond to your question, but you had asked for a moment of personal time.
Yes, ma'am. He did. Delegate Levine, thank you for doing that. I also wanted to say I'm glad it happened in South Carolina, not in Virginia. Thank you.
Okay.
And thank you again for citing your source.
Delegate Levine, do you have any closing comments?
I do, Madam Chair, and I'll be brief. I know it's been a long discussion. I think there's some misconceptions about this legislation. If you look at the impact statement and put together by DSS, put together by Imparenti, it makes clear that 0 children are expected to be impacted by the original version of this bill. And that's because the bill gives time if there is a move, but generally what the move means, I want to be very clear, it doesn't mean parents are suddenly saying, I don't love you anymore, foster child. What it means is that their services, their checks come from a different faith-based organization. The vast majority of faith-based organizations in Virginia do not discriminate. And I think it's very important to point that out because the ones that do were conflated with the ones that don't. And actually some discriminatory agencies like the one you heard don't take Virginia funds. So the bill has to do with the 1 out of 159 that actually takes state funds and discriminates. And the last thing I would say is that, remember, this repeals a law that was put in place in 2012. Virginia had foster care agencies long before 2012. They had religious, faith-based foster care agencies long before 2012. They had discriminatory ones as well. All this does is return the law to where it was then. And then we don't have in the code an express protection for religious-based discrimination. It would be up to Virginia to decide what to do next. I do think that Senator McPike, along with Senator Mason, would improve current law. I would prefer that the whole thing, frankly, go. But I understand the way this works, and I do think it is an improvement over the current law. And with that, I'd ask people to support it.
Thank you, Delegate Levine. As you know, making laws, we have to think about lots of implications, and it is far-reaching. So I think this midway step proposed by my colleagues is probably the prudent approach at the moment.
Madam Chair. Madam Chair. Madam Chair.
Senator Boysko.
Thank you. I'd like to thank Delegate Levine for bringing this up. This is, as you know, something that's important to me personally. But I really appreciate all the testimony that everybody gave, because I know that all of us in this room and everybody who has participated in this hearing cares about children first and foremost. And I think that I am very pleased that Senator Mason and McPike have worked hard to try to find consensus, and just really wanted to express my appreciation and gratitude for this whole process.
Thank you, Senator Boysko.
Madam Chair.
Is it Senator Mason?
Yes,
ma'am. Thank you, Madam Chair. This is probably one of the toughest bills that I've looked at this year. The first 5 or 6 speakers and their organizations have taught me every single thing I know about foster care and adoption in the last 3 or 4 years. And I think they came supportive of the original, and maybe some swallowing hard to support our combination. And let me be super clear. If we could line up same-sex couples to adopt every single kid or foster every single kid in Virginia right now, I would quit my job and work to help them do it. I think they're amazing parents, they're amazing opportunities for kids, and we want to place everyone. Where I struggled with this one is with so many children waiting adoption, waiting foster care. We're constantly talking about reducing our population in group homes. I was just very torn by anything that could conceivably impact the placement of children. I thank Senator McPike for such hard work and extending this. We'll see what the court case holds. We push it out a year. We remove the Section C, which I think is very important to us all. But this was a difficult one, Madam Chair, and I appreciate everyone's work and appreciate your indulgence.
It was challenging, and fortunately, I think everyone here shares the same goal about providing the best care for each child in the Commonwealth, and we always want to act in the best interest of each child. So we're trying to do that, and we're trying to do it in a way that is fair and that really recognizes the attributes and values that every organization can bring to the table.
Madam Chair.
Any other comments? Senator Stewart.
Thank you, Madam Chair. As I would echo the comments of Senator Mason, except I remain torn. I'm not Catholic, but I respect another individual's religious rights. And that's what disturbs me about this bill. I agree with Delegate Levine, and I don't find myself agreeing with Delegate Levine very often, quite frankly. But I agree with him that we should not condone discrimination against lesbian and or gay couples, that they should have the same equal rights as everyone else. But as I understand it, there are agencies that will work with those couples and place children with them. There are those that would prefer to go to a Catholic placing agency, and I guess this bill boils down to Catholics. While I would agree that there should be a path to end the discrimination against lesbian and gay couples, I don't see that we should be infringing on the Catholics' religious beliefs. And in an effort to do that, today with this bill, the only people that end up suffering are the little children that need a home, and for that reason, I can't support this.
Colleagues, the substitute is before us.
I move to report the substitute as amended.
Okay, a motion has been made by Senator Mason and seconded by Senator McPike. This does not have to go to Finance, so this will go right to the floor. And I want to personally thank Delegate Levine for taking this issue on and the enormous work you've done to really move our Commonwealth forward, to make us the welcoming place we want to be. So I'll ask the clerk to open the roll.
Ayes 8, noes 7.
Bill reports 8 to 7.
Thank you, Madam Chair, members of the committee.
Thank you. I believe that concludes our agenda for today. Is there any other business to come before this committee? Hearing none, I will accept a motion to adjourn. Okay, colleagues, having no other business, the committee shall rise.